So let me also reiterate what every other speaker has said so far, which is a sense of gratitude to Catherine and Kate and others for organizing this. Times 12 in the case of the panel that you are currently observing, because, and to my fellow panelists for being flexible, because this panel was originally scheduled, as you know, for tomorrow, and then because of a joyous event in my family that means that I have to be in Chicago tomorrow. Everybody was flexible enough to switch around. So here we are, and that act of generosity on the part of our host, because I've organized a lot of conferences and you don't always get that, is deeply appreciated. What I'm going to give you today is a kind of report from the ground. This semester, as I've been doing really for, I don't know, 2 years, I am teaching law and literature to law students. In fact, I did this at the University of British Columbia. I'm pointing, I think, vaguely in the direction of the law school. I understand there's a new law school building. Quite a while ago, 20 years ago. And I guess I've taught really thousands of law students over the course of time. Though I started out by teaching literature students about these same texts. And the report from the ground consists of a bunch of papers. I'm not going to read from all, but I'm going to read from some of them, that I just got from my class this semester of lawyers responding to notes from undergrad. And I asked them 2 questions. I said, there's a Dostoevsky mantra that goes, love life, not the meaning of life. What does that mean to you? What do you take from notes from underground as exemplifying perhaps that mantra? Although the mantra itself comes from another Dostoevsky text. And secondly, and in a sense more to the point, what as a budding lawyer, as a prospective lawyer, do you, the student, take from notes from underground? What moved you within your professional capacity? Are there any cautionary moments in the underground man's part 1 and part 2 narrative for you as a law student? How does the text resonate for you? And all of you in this room will probably figure out immediately that the choice of notes from underground as a text is unusual for a law and literature class. The law and literature class historically has certain canonical works involved, and they usually relate to one of 4 elements that link law to literature and vice versa within narratives. There are famous trial scenes. There are representations of lawyers. There are works that have to do with statutes. There can be attacks on statutes. Harriet Beecher Stowe, the muckrakers of the 1920s. And then, generally speaking, the relationship of justice and the individual. Well, notes from underground may be tangentially related to one of those 4 elements, but not really. It's true that the underground man talks about justice. He talks about revenge. It's a big part of the opening part of his examples in part 1 about why l'homme de la vérité, de la nature, the natural man, exemplified later by Zverkov, are able to go directly towards a goal. Remember that? Whereas people like us, the underground man, the intelligent person of the 19th century, is incapable of taking any action, is blocked by stone walls. The person of action recognizes the existence of stone walls, he tells us, but it doesn't stop them from doing things. They still will try to take action in the direction of what they conceive to be worthwhile, meritorious behavior, including sometimes the quest for justice, sometimes through revenge. There's an allusion there also to Hamlet. But in general, Notes from Underground is not really as law-related a text as most of the ones that we choose, which are from the 19th century, Billy Budd Saylor, usually, let's say, Great Expectations by Dickens, and sometimes Balzac, and we go back a little bit to the Greeks and into the 20th century, Camus, who writes an awful lot about law in one of the four ways that we schematically set it up in L'étranger and La Chute, and Kafka, and then you can go right into popular culture, which continues to be full of lawyers, lawyer figures, trials for mass audiences, much bigger than what we learned earlier today, much bigger audiences than Dostoevsky possibly could have even dreamt of. But I think Notes from Underground has its place. When we have time within the law and literature class, that means when we're not teaching Great Expectations or Bleak House, which is the other great Dickensian text about law, it's about chancery proceedings. We may have time for Crime and Punishment and or the Brothers Karamazov. And those texts are exceptionally, exquisitely important for lawyers because they teach people how legal reasoning goes bad. And I think Amy Rodder just alluded to some of that. I'm not quite sure I completely agree with her representation of Fedyakovich, the defense counsel, as a blockhead. The guy was very, very smart, but he definitely makes some strategic blunders. If we have more time, we may have to talk about it later. I think the reason he says what he does about confessions, he's got an idea in his mind about why he seems to endorse the notion of confession. He doesn't do a good job for his client. There, I will agree with you, but I think it's for different reasons. But the main thing about Crime and Punishment, and once we recognize, as I hope everybody in this room, everybody in the province that we are in right now, in the entire country, the continent, and the world, will never forget, is that Crime and Punishment is not about a police detective and the way a police detective investigates Raskolnikov's crimes. It is about a lawyer, судебный следователь. It's about a key figure in the reformed system called the examining magistrate, a figure who's adored by most European novelists. Because the examining magistrate is charged as a lawyer with lawyer-like skills to investigate serious crimes. Porphyry is one of them, and you have an examining magistrate in the Brothers Karamazov. And what Dostoevsky does is, in both of these great texts, is to explore the pathway to legal error in some detail. About 1/4 of the Brothers Karamazov has to do with the criminal procedure involving the parricide. That's an enormous amount of space. Track it. You have a preliminary investigation. You also then have a lengthy trial in which Fedyakovich appears, and you have Nikolai Krylovich on the side of the prosecutors. A vast expenditure of ink in the midst of what looks like, and is definitely, a crime novel or a detective novel, on the sheer technicalities of legal procedure. He was absolutely fascinated by legal procedure. But more importantly, the reader tracking carefully the process of investigating Mityev's supposed guilt or the penalty that Raskolnikov suffers in Crime and Punishment tracks as in no other vehicle available to lawyers or to laymen. Tracks why it is that mistakes are made, how are mistakes made. Both novels end in legal errors, as you know. And I would love for our students, if they have time, to have one of those two longer novels to read for that reason. Incidentally, the classical work on legal error in Dostoevsky and other modern novelists is by a person who's one of my dissertation advisors at Cornell named Wolfgang Holtheim. I don't know if you know his work. It's called, you and I have similar.
Brilliant.
Genau. Und sehr gut. I knew that you would know. Der Justizierte was literarische Problematik, a little classic from de Gruyter in the late 60s, before anybody was really writing about this. He also writes about Dipana by Durenmatt, and he writes about L'étranger. It's just fortunately about to be translated by one of my graduate students, and you'll all have access to Holtheim's work. This is enormous for students, but I think also for scholars and other people in the legal and general community. Mistakes are made not because novelists like to portray a legal system that is in bad distress. It's not so much because lawyers and the legal system are the butts of satiric barbs by writers. It's quite different. Writers are fascinated and involved in the process of examining reality, just like lawyers do, and setting up a narrative structure around that reality. Both of these fields, which seem so different, literature on one hand, narrative, storytelling, and law on the other, have very similar structuring methodologies. A reality presents itself, not in its total fullness, but somewhat inchoately to the imagination of the writer or factually to the lawyer. And it has to be reconstructed, it has to be narrated. And in these great novels, I'll get to Notes from Underground in a minute, in these great novels by Dostoevsky and in many other iterations, earlier by Balzac, later by Kafka, by the American novelist Malamud, a tripartite structure of European criminal procedure is represented. And little by little, you see various narrations of the event. For example, the history of a family in the Brothers Karamazov. We know a little bit about the Karamazovs, but then the legal system kicks in and you have two additional narrative versions of the Karamazov family in the preliminary investigation and at the trial. And little by little, tangible errors are made. And the result, by the way, I'll just tell you personally, for me, is quite thrilling. Because the long literature movement, as we sometimes vaingloriously call ourselves, as opposed to certain critical legal studies movements and critical movements generally, does not confess that the law always is indeterminate and prone to error. There is within these texts a tangible, seizable pathway to a just outcome. But the figures involved, Billy Budd is another example in the American context, the figures involved who are in charge of performing the legal recreation or legal interpretation go wrong. They are personally flawed, as is true. I still want to sort of protect Petrokovich for a minute, but it's certainly true of Ippolit Kirillovich. There's a problem with Ippolit Kirillovich, incidentally, vis-a-vis Dmitri. Maybe you remember there's a little bit of ressentiment, there's a little bit of the thought that Dmitri was going after his wife. Remember that?
Yes.
Ippolit Kirillovich is personally motivated, but the whole structure of the prosecution argument looks like rationality and incarnate. It isn't, it's tilted. And we have to know why lawyers and legal figures or authoritative figures, we have to know why they make so many mistakes. In the case of Raskolnikov, okay, Porphyry, brilliant. You'd agree with that, wouldn't you, Amy?
Yes.
Not a blockhead. Very creative. Finds the right guy, dismisses other confessions as not worth his time. But he also makes a terrible blunder at the end. It's also a judicial error because the sentence that Raskolnikov gets is enormously lighter than it should have been. What you have in that story is or at least one premeditated murder, and then you have a second murder side by side with the premeditated murder. And Raskolnikov gets a couple of years in exile, and that's because Porphyry arranges that. That case never even gets to trial, or it will be a very short trial. Incidentally, in the European system, which is different from ours, when a defendant confesses, the case still has to go to trial. It's different from our system. Because, exactly on your terms, they are more skeptical, at least the non-blockheads, of confession. They're more tuned into the irrationality that motivates confessions. We, I think, unfortunately, in our Anglo-American system, put too much faith in a confession. Their system has a certain check on that, but it also has the effect in Raskolnikov's case of short-circuiting what should have been a much longer trial and permitting the error of having Raskolnikov given an extremely light sentence. Notes from Underground fits into the law and literature class just as Hamlet does. And all of you in this room will know immediately, or remember how many allusions to Hamlet there are in Notes from Underground. Now, it's not only the revenge paradigm that so fascinates the underground man in both parts of the story. It's what might be called the over-analysis, the problem of the over-analytical individual, is a direct re-invocation of Hamlet. Hamlet, by Act 4, and I teach the text side by side, and neither of them has anything to do explicitly with lawyer figure, etc., or a trial. Hamlet finally figures out in Act 4, Scene 4, that part of the reason for his delay is what he calls cornering a thought. He says, a thought once quartered hath every one part reason to every 4 parts coward, or every 3 parts coward, where he sets up an image of drawing and quartering, where if you're faced with a pure thought, something that you really want to do, let's say revenging on your father's death, that kind of personality divides the thought endlessly. And in dividing the thought, in quartering it, it loses its original pure force. And Hamlet's smart enough to figure out at the end that that's, in effect, what has happened to him over the course of the play. I don't know that he immediately reforms himself. It still takes a number of other things to goad him to action. The Underground Man is an example of a figure who also thinks things through to not only a logical conclusion, but to every conceivable end that his mind, often his feverish mind, can come up with. In fact, here's what my students took out of the reading of the stories that they felt was important to them as readers. About half the group felt that the Underground Man could be charged with the characteristic, for better or worse, of over-analysis in the way that I've just described it to you. And the other half were attracted to irrationality in the thought of the Underground Man, including themes of suffering, which are really non-Western themes that Dostoevsky, of course, brings out. I would rather prick my hand and draw blood from my own hand than live in the Crystal Palace, live in the beautiful environment of comfort. That theme of irrationality going so far as to become self-destructive is not immediately intuitively apparent to Westerners, much less Western lawyers. And there are other forms of irrationality within Notes from Underground. And here's the paradoxical part of this. The students wound up almost unanimously seeing those two qualities and preferring irrationality as an influence on their legal training to over-analysis. Now think about that for a minute, because we train our students to quarter thoughts. As part of their training of a lawyer is to see all sides of an issue, precisely to do what Hamlet finally figures out can be a problem in certain circumstances. Okay, the landlord wrongs the, looks like the landlord wrongs the widow and orphan. They come into law school thinking, obviously the widow and orphan are going to win and not get kicked out of there. And the thing the law professor does immediately is, no, just a minute, let's think about that. That would be scanned. Aren't there these other factors within the situation that we're talking about that have to be thought about before you decide that the widow and orphan are going to always beat the evil landlord? And in the process of 3 years, law students are taught to overanalyze in the sense that that's what people want from lawyers. They want lawyers to see as many different parts of the situation as can possibly go on. Yet, overanalysis coming out of Notes from Underground is revealed by students to be a problem that they need to avoid as lawyers. It was quite fascinating that they took from the story, sometimes you have to stop thinking at a certain point in order to be able to act. I'm going to read you, I'm not going to have time to read too much because I think I'm running out of time, but let me read you one paper. This one I like very much. When I read that Lisa decided to actually go and pay the Underground Man a visit, I initially wanted to protect her, said my student. and tell her to turn around and just go home and stay away from this bitter character forever. But I realized that Lisa doesn't know the underground man like we do. And I put myself into her shoes with that in mind. If a curious and seemingly troubled person left me their address after a random encounter, I would see it as a cry for help. As a decent human being, helping a person I think is reaching out for attention would be the morally right thing to do for me. Now, here's the little turnaround. But as a lawyer, she says, I am conflicted. On one hand, the primary role of a lawyer is problem solver, and the more challenging the problem, the more intriguing it is. So my instinct would be to want to know more about this odd man and his troubles so that I could work to help him resolve them. Going to the underground man's home would seem a natural next step of that investigation. On the other hand, one of lawyers' most characteristic traits is their risk aversion. So as soon as I had one foot out the door to investigate, I would think of reasons for not going further with my original intuition that maybe it would be a good idea to visit him. Maybe, she says, that makes me an overthinker and ultimately a person of inaction. And that's something she wanted to think about within her professional role. Overthinking was seen by many of the students as something that they had to really keep their eye on, even though our profession is based on overthinking, constant analysis. And I think that's a wonderful lesson for them. And it partly explained for some students why so much in our political and legislative world is going wrong, why there's too much, maybe too much cerebral, some of this blamed on an inability to take steps, finally figure out what is the policy of the country, et cetera, and legislative inaction, et cetera, but especially within their own professional world. I'm just going to take one more minute. On the other hand, irrationality, which we don't think is part of what we're trying to imbue our students with, irrationality, got very high marks coming out of the story. And I'm going to tell you in exactly what ways. And this partly gets us back to Fetchikovic. The students seem to understand that unless a lawyer can understand the way most people in the world think and feel, they're not going to be good lawyers. And most people in the world do not think in terms of rationality. Most people, as Dostoevsky shows over and over again, work against their own self-interest. And they need to have lawyers who understand that. They need to have lawyers when they're dealing with their clients who understand that the client has not gone to law school and has a whole host of feelings and insights into the situation that can be useful to the lawyer that wouldn't be set down under the rubric of rationality. A lawyer dealing with a jury has to be aware of the fact that a jury as a body is not a group of platonic wise men and women, but people drawn from the community who have all of the prejudices of a community, and as well as all of their embedded but unspoken wisdom. And the lawyer has to know how to draw that out. The lawyer is not taught this in law school. So when you read a story like Notes from Underground, it's a golden opportunity, and I didn't expect results that are, at least I hope you all have found as well, as interesting as they are, about how much people are able to feel from that story professionally vital insights that they really don't get anywhere else. And I think the story will stay with them for that reason. Thank you very much.
Thank you.